Family disputes can make us feel isolated and vulnerable. Maybe you're going through a divorce or a legal dispute about your kids. Perhaps you've spent hours on Google or have even posted anonymously on Facebook to see what others have to say. But are you getting the actual information and support that you're looking for? Our podcast, Legal Lounge, aims to dispel misinformation and downright bad legal information to empower anyone with questions about their family, their children, their finances, their marriage, and the law. As a team focused exclusively on family law matters, we aim to help listeners not only with the information they need, but also with the hope that their situation has a solution. Short disclaimer, please note this podcast is for educational purposes only, and the information should not be relied upon as legal advice or for legal purposes. And we're back on the Legal Lounge. Today I have a wonderful guest with me. Her name is Deb Dilman. She's one of the attorneys with Modern Legal, and we're excited to have you here today. Tell us more about yourself.
Hi, thanks, Theresa. Yes, so I'm Deb Dilman. I have been practicing family law for about 19 years. Been a practicing attorney for almost 21. I am also a certified mediator in both family financial work and also superior court, and collaboratively trained. And when I'm not working, I love to read and exercise and just hang out with my peeps. So thanks for having me.
Of course, happy to have you. I know we were just talking about exercise and running, and so my goal is to get back into running too. So
Awesome.
I appreciate
We'll do it
that.
together.
Yes, let's do it.
Couch to 5K.
Exactly. So let's get into what you pointed out just a moment ago about being a certified mediator, because in today's episode, I really want to expose some different aspects of mediation for the listeners. And being a certified mediator, what does that mean?
So there's different types of mediators. You can be an attorney or a non-attorney and mediate. You can also be certified or not certified. So you can be an attorney, certified, not certified. You can be a non-attorney, certified, not certified. And what it means to be certified is you've gone through an additional series of classes, about 40 hours to become certified. And then it allows you to meet the statutory requirement of mediating property settlement cases before you go to trial, but you have to mediate with a certified mediator. So it gives you an added level. It gives people who go to mediation, I think, an added level of confidence that they're working with somebody that knows what they're doing.
Yeah, that's a great point. Because I have gotten calls before of, we don't necessarily want attorneys because we want to amicably resolve the case. We've heard about mediation. What do mediators do? And it's very important to note that basically anyone can be a mediator, but not many individuals may have the experience of also being a family law attorney.
Right.
So if someone is a family law attorney as well as a mediator, they at least know when certain information may actually turn into legal advice versus non-legal advice. Side note here, get your legal advice only from attorneys that are licensed to practice law in the state where you reside. And specifically here in North Carolina, we also have that certification process that you were just noting. That's a fun certification process. It was pretty intense, wasn't it?
It was really intense. And I did it differently. They have different classes, and I did it on weekends instead of taking time away from my clients to do it during the week. So there's all different, but it's pretty intense.
Yeah.
It's a lot of fun, though. You're with like-minded people that want to do the same thing. But to your point about being a family law attorney, not only does it help guide you when you're trying to deal with legal advice, but also as a family law attorney, when people come in to mediate, we know the local practices, right? So if litigants are on their way to litigation and they have a particular judge, at least we can comment or understand how that judge normally handles things, which I think is also very helpful. And some of the attorney or non-attorneys who mediate don't have that experience because they're not in the courtroom all the time. So they don't know the local practices of the judges or just our local practices here in Mecklenburg County or Union County, Cabarrus, wherever we might be.
Yeah.
So I think that makes a difference too.
Yeah. And with our Modern Legal office located in Charlotte and serving clients throughout the North Carolina and a little bit into South Carolina as well, it's very interesting how different the counties practice.
Correct. Yeah. It's a little scary. I mean, the laws are the same, but it's really frightening sometimes, especially to people who are not attorneys, it's frightening at how different it is in the different counties, conservative, liberal, whatever, but it's very, very different.
Yeah. And so knowing your judge, knowing your courtroom, even knowing the other attorneys in those counties of practice, that's important information because a lot of clients simply just aren't exposed to that world. I mean, I've had the client that's come to me and said, I haven't even gotten a traffic ticket. What does this mean to be in a courtroom or possibly be sued for my children, my property, and a whole host of other matters that come up in family law disputes?
Yeah. And side note to that, I remember in Hillsborough County, which is out in the Triangle area, I got a traffic ticket years ago. And so I went in, I was dressed for work, kind of like I'm dressed today, went in and waited my turn. And there were people all over the place. And finally, a woman next to me who was also dressed as nicely as I was in clearly work attire, the judge called us to the front. And he's like, I have a gun underneath here. You do realize that we have all kinds of cases in here. What are you ladies here for? So I didn't understand that local county, but they had like people that were charged criminally along with traffic all in the same courtroom and with the same judge, and they had no idea what was going to happen.
Yeah.
And he was, looking out for us. And we're like, yeah, we're here for a traffic ticket. I plead guilty.
Yeah.
Like,
I'll take
just
my
give me
fine.
A prayer for judgment. Fine, let me out of here.
Let me go.
So, yeah, exactly. So not mediation necessarily, but yes, the local rules can be very, very different depending on where you are in the state.
And go one step further, there is like traffic tickets or criminal law. Those are handled by certain judges. And in pretty much all the counties in North Carolina, you will have a specific judge in your courthouse that does the family law matters. Now, judges do rotate, so that doesn't necessarily mean that they'll only stay in family law for their whole tenure. But it is interesting because the family courts have different practices from even the criminal courts in the same courthouse. So it's really important to know that if you are working with a mediator or if you're working with an attorney as well, that they are a family law experienced mediator or attorney and in the area of, the county where you have your case.
Absolutely. Yep. I ditto that.
Yeah. So let's shift to the actual Dispute Resolution Commission, which is the regulatory body over mediators. Do they have resources for, say, a pro se party or really anyone going through the mediation process?
Yeah, they have a whole website. So it's the North Carolina Dispute Resolution Commission. If you Google that, it'll take you straight to the link. It's part of the judicial branch. So it's connected to nccourts.org, but you can find a mediator there. You can search for mediators in the county where you are, and it'll tell you who's certified and who's available in your county. But they also have resources for individuals who are facing mediation who may not have an attorney. So there's a link about how to prepare for mediation if you're unrepresented, which is super, super helpful. There's a couple of links. You have to go a few dives in to get to equitable distribution for family financial cases. But it walks you through the general process and then it narrows it down for you. And you can get a whole list of documents that you need to bring with you to mediation, it's just helpful information to have so that you're prepared to make your mediation as effective for that day as possible. And it helps the mediator too, because the mediator is not an attorney. So the mediator can't really advise you on exactly what it is that you need to bring with you to mediation.
Yeah. So 2 points there. And just for our listeners, if this is the first episode you're listening to, equitable distribution is the process by which property and debts as a result of a marital relationship are divided. So, Deb is pointing out the fact that, hey, we may need a listing of all your assets and debts at the mediation itself. And that plus a lot more is available at the DRC website and the resources. And then the second point is even if a mediator may also be a family law attorney or an attorney otherwise, when that person is wearing the mediator hat, they cannot give legal advice. Which I want to stress that because, yes, they may be a family law attorney and they take clients privately. But if you are someone seeking the assistance of a mediator and you try to call the mediator to do a consultation, for example, they're going to say, no, I can't give you a consultation because I can't give you legal advice.
Can't give you legal advice, can't act in any capacity after mediation. Like there's been cases where folks have needed a parenting coordinator and the mediator cannot act as a parenting coordinator after they've mediated, which is all regulated by the Dispute Resolution Commission. And then mediators cannot draft any documents, and technically they shouldn't be editing documents either, which is something the Dispute Resolution Commission is looking at because it is really difficult for pro se litigants to understand that, yeah, you've got to now go to mediation, pay for a mediator, and now you've got to go pay an attorney to draft a document for you.
Yeah.
And it's expensive.
Yeah.
So the dispute resolution is looking to see if they can convince the chief district judge, Newby now, and his group to actually allow mediators to actually draft documents. But as it stands right now, we can't draft. So mediators will just give you a list of attorneys who are willing to draft documents for you, and you can just go use one of those one of those attorneys for drafting.
Yeah. And I want to stress here, whenever, say, a person who is going through the separation or divorce process, and maybe you also have a high conflict custody matter ongoing at the same time, trust me, it's not the person you're calling or the mediator that you're trying to get help from that is making this process difficult. It's that we are a highly regulated industry, if you will, both as attorneys and as mediators. And we got to follow those rules because we cannot sacrifice our certifications and our licenses simply because one client wants more information.
That's right.
Which is huge, especially when, you know, parties are like, well, I don't know where to find the information and I don't know where to look. And a mediator can kind of talk to someone, a party, before the case goes to mediation itself. But the problem is as a mediator, we can't learn too much about the situation and we can't discuss legal tactics at all, because then that will remove our impartiality. And you want an impartial mediator because the mediator wants to be focused on finding a middle ground, that amicable resolution. That's the goal, not necessarily to advocate for either party.
That's right. Yep. And that's the difficult thing for people to understand. It's like we just can't do it for lots of reasons. It's like we're double regulated. We're regulated as attorneys if we are attorneys, and then we're regulated on top of that by the Dispute Resolution Commission. And sometimes those regulations conflict, but we are required to follow both of them. So it's hard to deal with sometime. And sometimes I'll tell people that don't have attorneys and haven't had a consult with one that maybe they need to see if they can find the funds to meet with an attorney ahead of mediation, just so that they better understand their legal rights coming into mediation. And, a lot of times there's churches or other community organizations that may be able to assist people that can't afford it, but the help is out there. It's just a matter of seeking it and finding it, just to better prepare yourself for what's coming.
Building relationships is a natural part of life. But how does the law affect those relationships? Do you want to marry your significant other, but have cold feet from the many divorce horror stories out there? Are you preparing for a custody battle against your ex? That is where Modern Legal comes in. We offer education and knowledge about the law when it affects the relationships near and dear to your heart. To learn more about how family law affects your family, book a consultation with an attorney of our Modern Legal team by visiting our website, emailing us, or calling us at 704-286-6302. Check out the information about Modern Legal services at modernlegalnc.com.
There's this misconception, I would say, that you don't need an attorney when you go to mediation, which is technically true. However, if you go to mediation, the mediator cannot answer any of your legal questions. And so I have seen time and time again, someone has tried mediation once, twice, or more, and they are in a room, a conference room, separated from the other party. And if that other party has an attorney, there may be a power imbalance. And so this person who's representing themselves will have a lot of questions, but no one to answer those questions in the mediation process. Have you seen that too?
I have. I've seen that a lot. And it becomes, as the mediator, you have to show a lot more empathy for the individual that doesn't have an attorney there, but also to explain that I want to give you legal advice, but I can't give you any legal advice. You can Google, and that's about all we can do. But I will say, when I've been contacted by a pro se litigant that doesn't have an attorney or has met with an attorney but hasn't technically retained, I have suggested talking with that attorney to see if that attorney will schedule an office day the same day that person's in mediation, so that if the litigant does have a question, the party does have a question, they can actually, phone a friend, right?
Yeah.
Just kind of call the or the attorney and just say, hey, this came up. I don't really understand it. Can you briefly explain it to me? And I have had some people do that. It's rare. But it can work. And then the attorney can just, be in the office billing and working on other client stuff unless a call comes through. So
that's a great idea.
Yeah, it's an option that's available to anybody. But it is hard. There is the perceived power imbalance when one party has an attorney, but not everybody can afford attorneys. So we just deal with it.
And another point, and this actually does shift if mediation were to fail and a pro se party is going to court, at least getting the documents prepared and having them reviewed by an attorney. So for example, we have asset debt charts or what we call equitable distribution affidavits, and maybe someone can't afford an attorney to do it for them, but an attorney can definitely review what someone has, or if someone is able to bring all their documents to say a consultation, then that attorney can at least help them with the paperwork, because as a mediator, I can't give legal advice, but I can definitely look at an asset debt chart or an equitable distribution affidavit and be like, okay, I know what you're saying here. Let me take this to the other side.
Right.
And that is a lot more productive than someone saying, ooh, what is this form? I have never seen it before.
And sometimes, when there's that imbalance and one of the parties does have an attorney, they may be willing to share an asset debt spreadsheet. Just outlining what assets and liabilities are even there, just to make sure we've got them all and that everybody understands this is what we're dealing with. And then we can talk about valuations of those things and what's appropriate for a distribution. So it is helpful, but there are options.
And I know we focus a little bit more on the equitable distribution side, but on the flip side, I would say mediation is also a great tool for any child custody or child support issues as well.
Anything that's pending in litigation. I mean, I personally believe conflict resolution is conflict resolution. It doesn't matter what it is, right? Yeah. I'm a good person to deal with conflict resolution. So any issue you may have, bring it on.
Yeah.
So alimony, spousal support, custody, child support, equitable distribution. You're only ordered to do some sort of alternative dispute resolution through statute. For equitable distribution, you do have to do custody mediation through the courts. But most of the time when there are more than one thing pending, they'll just bring it all to mediation, which is great. Yeah. It's just additional preparations. Like if you've got a support issue, you want to come with your budget. Like what does your budget look like? Yep. A lot of people work with budgets. A lot of people don't work with budgets, especially if you've got that imbalance in the marriage, where one was the financial breadwinner and the other one wasn't. The one that wasn't may not know what bills are out there and what needs to be paid. So it does take some time in finding the right person. And there are people in Charlotte that can help you do that if you're unfamiliar with doing your own budget. Yeah. But, bringing all that.
A plug here, CDFA, Certified Divorce Financial Analyst. And there's other Legal Lounge episodes on that. But great point, Deb.
Mm-hmm. Yeah. So it's hard. And, the nice thing about mediation, and I may be jumping ahead, Theresa, I don't know. But the nice thing about mediation is the process itself is confidential. So it's inadmissible what we talk about in court if you don't settle it. So you can be comfortable to sound and say whatever you want to in mediation. It does not matter. That information is not going outside of that mediation day. Yeah. Which is nice.
Yeah. So. At least to be used against you in a courtroom.
Correct.
Yeah.
Right.
Which is what, if we put the lawyer hat back on or the litigator hat back on, that's what we care about most, right? Because if it doesn't settle, then it's going to go to a judge.
That's right.
What information can go to the judge? That the only information is whether or not you attended mediation and whether or not you had a resolution or not.
That's right.
And trust me, if you're in front of the judge for all these issues, they know it failed.
Yeah, so exactly.
There's that really good point.
That's so true.
And I just want to touch on custody as well. I think meeting with an attorney before a mediation, if you can't afford to have an attorney by your side at the mediation itself, it's really important to talk to an attorney about custody as well, because I understand a lot of clients know that, say, for example, during the marriage or during the relationship, they were the primary caretaker, or they know all the doctors, dentists, teachers, etc. And it could be a hard pill to swallow if you get to mediation and suddenly the opposing side is asking for a 50-50 custody arrangement, and you don't know why they're coming from that perspective. Well, if you sit down with a family law attorney, we can explain why, they're coming from that point. And second off, maybe it's, a consideration of other things that you may not know to bring up unless you talk with an attorney. So for example, I've had this all the time where, both parties want to do some type of 50-50 arrangement, but maybe their work schedules simply don't allow it, or travel schedules, or just, what shift they're on. Because if a parent has a night shift, so even though they only work, say, 3-4 days a week, if they have the night shift, then they clearly can't care for the child when the child's sleeping in bed at home. And these are factors that a mediator can't necessarily explain, but an attorney can.
Yeah, absolutely. The mediator's role in situations like that becomes more of dealing with the emotional response versus the legal response to those things, and working empathetically with the parties about, what can you really manage? Like, why is it so important to you to have 50-50 schedule if that's what you want, and then working through them individually about why it is that they are interested in that versus trying to get back at the other person.
Yeah.
So it's just spending a lot of time that way. And mediators can do that, right? Without going into the law. And that's what we're good at.
Yes.
Is doing with that, dealing with those issues. Someone told me a long time ago, every one of these cases has two sides, an emotional side and a legal side. And I think mediators see that more than anybody else practicing,
I completely
because
agree.
we deal with that because it's confidential. So they can unload on us. And that's fine.
And we're ready for it. Don't worry. We don't get insulted.
Exactly. Not at all.
And we have plenty of tissues in the office because it does happen.
Yep.
So let's delve into the process itself. Like, what does the process of mediation and the day of mediation look like?
So there are two types of mediations. One can be virtual, which we started doing during the COVID pandemic, and we've continued that process. And that's actually the default by the Dispute Resolution Commission if the parties can't agree to come in person. That default might change, but it hasn't changed yet. Most of my mediations, I think, are more effective if they're in person versus virtual. So the day itself can be different, whether you're virtual or in person, but the breakout of the day is the same. So what we typically do is what we call caucusing, which the mediator goes back and forth between either a virtual room or an in-person room, trying to meet with both sides about what it is that they want, what their needs and interests are.
And the parties are in separate rooms.
Parties are typically in separate rooms. We can do a joint meeting to discuss the administrative things that the dispute resolution requires us as mediators to go through. But I have found over the past couple of years that that's not always effective unless I know right away that the parties are able to be civil with one another for a period of time. So I've started doing a lot of those meetings separately, just going through the administrative stuff. So I caucus, I put people in separate rooms. They're not anywhere close to each other so that they typically can't hear what's going on in another room. And then as the mediator, I just go back and forth in talking with the people until we can get a resolution.
And physically back and forth if it's in person.
Yeah. I've said many times I should carry my phone with me so I can track my steps.
Yeah.
Going back and forth because it's a lot of walking back and forth, yes.
Yeah, and it'll help us with that 5K.
Yeah, exactly.
So it's
true.
literally a ping pong back and forth.
Yep.
And then the hope is, whether it's virtual or in person, that the parties have come closer together in their positions such that you get to that sweet spot, if you will, that settlement spot.
Yep.
How do you get the parties to cross that final line?
So it's interesting. I tell everybody that this works. And I learned this in an editing course I took years ago for newspaper writing, but it's an inverse triangle. So the first meetings are going to be very far apart and they're going to take longer. And as the day goes on, we're narrowing all the issues, right? And the hope is that we get to the bottom of that inverse triangle and we've settled a case. I let parties tell me as much as they want to in the first meeting. And I don't quash any ideas they may have because I'm trying to build a rapport with you. Mm-hmm. And then, I take that to the other side and most of the time I tell folks, look, you're going to give me your best offer. They may perceive it as their worst offer, but then the opposite's going to happen. They're going to give you what they perceive their best offer. You're going to think it's their worst offer. And then my work starts, right? And once I've got those on the table, I know what your extreme positions are going to be. And then we'll work together to try and narrow the issues. And I'll ask if there are attorneys present. I'll ask if they want to deal with one issue at a time, or if you want to do a global settlement. And then we'll deal with all the issues that might be pending at that time. So it just depends on the nature of the personalities and behaviors of the people who are there, and also what's so important to them. Some people just want to focus on custody, and if we can get custody done, then we can move on to something else. Some people are just like, I just want to deal with the financial. I can't even deal with custody today.
Yeah, and that's a great point, because going into mediation, I think a good goal to have, even if you have an attorney, is if you are the party going into the mediation and you have certain non-negotiables, know which ones are your non-negotiables up front. And it can't be everything, right? So it can't be, I'm not going to settle for anything less than all the stuff I want in every single category: child custody, child support, equitable distribution, alimony, etc. There has to be more like one, maybe two non-negotiables. Why? Because then that gives the opportunity for both your attorney, if you have one, but definitely the mediator, to push and pull in certain areas to hopefully have a resolution. Or I would say, even more importantly, maybe we also can identify if there's never going to be a resolution, because a non-negotiable is the same on both sides, and they're so far apart that there's really no use for the mediation itself.
Yeah, and sometimes it is rare, and this is also rare too, but sometimes people will come in and they'll say X is a non-negotiable. And when I hear that, a lot of times I'll spend a few minutes with the why question, like, why is that a non-negotiable? Because as the day goes on, it may be an untenable non-negotiable, like a house, someone that wants to keep a house. Like, I don't know that you can afford that house. Like, have you thought about, you're going to be married to your house now, sort of question. Yeah. So I do spend a little bit of time with the non-negotiables just to make sure they truly are non-negotiables and doable before we say, okay, we're taking that off the table because that's a non-negotiable.
And that's what makes you a great mediator, right?
So, we'll see.
Yeah.
I mean,
I try.
It's helpful. I try. I mean, I do really, and you do the same thing in your cases. We try to actually look at the person in front of us and actually look at that person as a human being and say, okay, this is what you're stating to me your needs and interests are. Can you meet those needs and interests? Before we go back there and say to the ex-spouse or whatever, father of your child, whatever you want to say, before we go try to negotiate that, are you really sure this is what you want? Because it may not be the best for you. And sometimes that means I can see, because you've given me documents, that the dollars aren't there to support what it is that you want. Yeah. But I'm also not a financial planner, right? Yeah. So I can't go out of my wheelhouse or change my lane. Yeah. I'm the mediator. Yeah. But we can say at that point, hey, whatever we do, there are people out there that can help you with the financials. And that should be your next step before we maybe even ink anything, just to make sure you can do it.
There's a lot of questions that come up in mediation. And so although most mediations do involve, say, one day of the process, and I will note here, it's usually a long day. So don't try to do this over the lunch hour. This is something that we generally start relatively early in the morning, and we expect to be at mediation all day. If we end early, great. And we have a settlement, great. But this is definitely not a short process. But go one step further. If everyone finds that, one side needs to see if they can get pre-approved for, say, a refinance, or what their financial circumstance is, or maybe they do need to meet with a CDFA or even a therapist for the child if the child is exhibiting certain issues, then the mediation can be paused and a second day can be scheduled. In my experience, that's rare, but it is a possibility. So we never want parties to think that, today it's one and done, or we're going in front of a judge. Because trust me, the judge will very much appreciate if you take a couple more days to mediate and come to a resolution than a judge who is technically a stranger to your family making all these important decisions about your family and finances.
Yeah, that's a great point. I mean, frankly, our judges don't want to make these decisions. And mediation is your best opportunity to stay in control over what the outcome is. And I tell people that when they come to mediation, especially those that don't have attorneys, like, this is really your last chance to try and get it resolved between the two of you, because the minute you step through that courtroom, it's gloves off, and you will never come out the same person. So you need to dig deep. You need to be willing to compromise. You need to be willing to do that. But you mentioned something earlier about adjourning versus impasse. And a lot of times people, they come, and I don't know how this happens, but they think they're only going to be here for an hour or 2 hours. And the Dispute Resolution Commission mandates that the mediator is in charge of the day. So that means I get to keep you as long as I think we're making progress. And that's a hard pill for some people to swallow because they've not been told that, by anybody. And so I have had to encourage people sometimes to call and make arrangements for someone to pick up children so that they can stay longer than 2 hours because we're making progress. I try to explain to the litigants that the reason I'm in charge is because I'm seeing the dynamic and the communications in 2 different rooms, and they're not. So they don't know what kind of progress I'm making in the other room, and vice versa. And so they need to trust me. It's helpful when there are attorneys for me, because attorneys know that I'm reasonable and I'm not going to keep you past, the time where I think we need to be. I'm going to let you go if we're not making any progress. But yes, we can impasse, we can settle, we can adjourn, and just come back to settle things on a different day.
Another plug for having the attorney. If you do have an attorney at the mediation, you basically have that on-the-spot advocate that can answer your legal questions. And since the mediator can't draft any resolution, that attorney can start drafting right then and there. That's why sometimes it's nice to have something in person, a mediation in person, because you can even leave with signatures that day, whether it's a consent order or a contract like a separation agreement. And finally, and this has happened to me as an attorney, whereas if I had a mediation one time where we were there past 6 o'clock, or we were slated to be there past 6 o'clock. And so my client was like, we had reached an agreement. It was 5:30. He was like, I do have to pick up the kids from daycare. And I said, okay, we have a resolution. You go. I'll finish drafting. I'll go back and forth with the mediator and the attorney, make sure everything that we have agreed upon is in this document while you take care of your kids. And lo and behold, I was there at his house at 7 o'clock at night getting his signature as well. And it was funny because he started showing me some of the furniture that they had discussed the whole day. So I was like, that's great. But that's just a plug to have an attorney, because then you are able to focus on some of those other necessities that come up when you have a family.
Yeah. And it's always good, I think, to sign a document that is either notarized so that it will hold up, or a final document so that people are done. Like and I tell folks, like, you don't want to be paying attorneys and dealing with this stuff for another 12 months. Let's just get it done. And you can get it done, and then you can sleep. The result you're going to get may not be what you wanted when you came in, but I can guarantee if you reach a resolution, it will be a reasonable result that allows you to put your head on the pillow and sleep that particular night, which is what you want.
I agree wholeheartedly. I've told my clients, and this is in my role as an attorney, where this can take a number of months, could be years. And it's interesting for my clients who haven't been able to resolve their case early on, especially through mediation. And they're like, oh, I didn't realize this would take years. And I'm like, I did tell you, right? And they're like, oh yeah, you totally told me, but
I just didn't believe you.
Because how could it?
Right.
And that's the reality. That's the reality of what our clients see. So to your point, it's great to have something that you're walking away the day of mediation if you're able to reach an agreement.
Yeah. And there's, there are people that don't want to sign things, and it opens yourself up for people who change their mind, which can happen. And I understand that too. But I do think the better thing is to sign something that day, even if it's just stipulations to what you've agreed to that we can file with the court.
Agreed. Well, I don't want to take too much more of your time. I know you have mediations and legal work to get back to. But Deb, thank you so much for joining us on the Legal Lounge today, and we hope to have you back soon.
Thanks for having me. Appreciate it.
Thank you for taking the time to listen to our discussion. To learn more about me and the Modern Legal team, go to our website, modernlegalnc.com, or check out the links in our show notes to follow us on Instagram, Facebook, LinkedIn, and YouTube. You can also call us at 704-286-6302. If you have been intrigued by the conversation and would like us to continue our discussions, please subscribe to the podcast and leave us a review. See you next time.